Hello, hello, hello. Hey there, everybody. Oh, you can't, nobody can hear me. Damn it.
Test, test, test. Check, check,
Hey
check.
there.
Hey, can you hear me?
Man, can you hear me?
Yep. Coming in a little
Good
Muffled?
morning.
underwater, but yeah. I see you now.
Yeah, we can see you now.
Yep, I literally just finished relocating all my equipment over the last week, and so still having some technical issues, making sure everything works. We'll let everybody in.
Your volume's still slow.
No,
Soft.
yeah, let me get my volume situated. How about now?
It's because you're facing away, I think, from the mic right now. I think if you turn
How
and
about now?
talk,
How about now?
there we go. You have noise canceling on?
Let me see. I'm on Zoom, so I'm not as. Let me move this over here so that I'm directly facing the camera.
Yeah, you'll hear better because the noise canceling, it gets used to the level or how far away you are. So if you move away, it cancels that out because it's a different range.
All right. Okay. We'll just keep messing with it and let people
You're good.
in.
I can hear you clear. You're good.
Oh, you can hear me clearly now. Okay, good. All right. I don't know how big a showing we're going to have today because we had a meeting about 3 weeks ago. There have been just two minor updates since then. One, I finally got the amended complaint filed. I got amended, had to file a motion to amend a memorandum in support of that amendment, and then the amended complaint. And then the amended complaint, Jason, this relates directly to you as public knowledge now, so I don't have to be too stealthy about it. But I added your State Department claim back in
Thank you
as
very
far as
much.
your wage and theft, which was dismissed without any discussion at all. And then I added your DOJ
Thank you.
wage and theft claim in there as well, wage theft claim in there. And then I got to look back. I think it's 6 or 7 new VOA people,
Mhm.
and that is for the purpose. Those people were already in the case, and I want to make sure everyone understands that they were already in the case by virtue of their opt-ins. But I named them as named plaintiffs because this Judge Summers is still operating under the assumption he's not dealt with any of the opt-ins. So I've added the additional named plaintiffs for the purpose of getting on with discovery so that I can find out where the rest of the thousands of VOA people are that haven't joined this case yet. Now, the importance of the other thing, the other piece that's happened is that the Court of Appeals, you guys might remember that I told you in our last meeting that we were fully briefed at the Court of Appeals on the equitable tolling, equitable estoppel, which is stuff that you guys are probably getting like a first year law school class here, but it's that is the mechanism that would allow us to reach back in time in perpetuity for and capture as many people who have been injured by the government's activities as possible. So that was fully briefed in early July. Um, the Court of Appeals typically takes months before they order paper copies. They ordered paper copies a week and a half ago and gave me 5 days to get them into the court, which was accomplished. I got that all. That's all.
Good
Um,
job. Woo.
well, I had to hire a
Good.
company to do it. I hired a company that does that job for a living. They're in DC. They're a print company.
Why was
Uh,
it so rushed, if you don't mind me asking?
yeah, I don't know that 5 days is necessarily that much of a rush, but it's done. It's in house. The government's responded with their copies, and now we're just waiting. The next step will be the court will send me an email. They'll send both parties an email. Matthew Carhart and I will get an email from the court that says, "Hey, look at these 4 or 5 months. Remember, the court only convenes for about 1 week every month. I think they begin in September. They take the summer off, and then they reconvene in September, and they take 1 week of every month to take oral arguments. And then the theory is they take the rest of that month to issue written decisions. So what I should get next is an email from the court that says, "Hey, let me know. Go through each of these months. That first week of each month, tell us what days you can't do oral argument, and then they'll get back to us with an oral argument date." Now, I think I've said this more than once, but the oral argument is a little bit of an anticlimactic event. They do all this preparation. It's like a pop. You fly in. I wait in the court like it's a DMV hearing. There are usually four. There's like 4 or 5 hearings scheduled for the morning and another 4. And all I'll know when I get my notice is that I'm in the morning or I'm in the afternoon. And so I'll either have to be there at 8:30 or I'll have to be there at like 12:30 in the afternoon. And then I go into the hearing, into the big chambers, and then I'll know the morning of the order in which they're being called, and I'll learn that morning who my panel is, the panel that I'm arguing in front of.
Oh, so we don't even know if it's not going to be the same people as before.
I have no idea. I mean, it theoretically could be the same people, but they don't announce that in advance. This is a separate appeal from the previous appeal, so we don't know if it'll be the same judges. It would be a boon to us if it were. That would be fantastic, because that last panel was pretty thoughtful and thorough. And then we have the amended complaint that I filed on Friday. The purpose of the amended complaint is what will happen next is that the government will get to file its motion in opposition to the amendment. I'll file the reply. There really isn't, I've said this before, there really isn't a principled reason for the judge to deny this motion to amend, because everyone I'm adding as a named plaintiff was already opted into the case a year ago. And we've limited the complaint to the 3 years that the judge said we could go. And we have, pending the appeal. And then we have, what is the other word? What is the other thing I'm trying to say? Oh, and then we kept the retaliation claims out. All of that stuff is subject to appeal. So I've colored inside the lines as far as Judge Summers' last order on this thing. But the purpose of filing now is so that we can get into discovery and certification. Judge Summers hasn't, the government filed a motion to stay on this case back in, I don't know, March, and the court still hasn't moved on it yet. So this Judge Summers doesn't seem to be in a hurry as it relates to this case. So that's where we are on everything, and I'm doing what I'm doing to try to, sort of force the court to move along. So you guys are the normal, the usual suspects on this stuff. So I'm not gonna belabor any points today. I just wanted to update everybody. Jason, your hand was up. What was your question?
So you said Judge Summers just kind of, without any conversation, just got rid of all my stuff from State Department, DOJ. And they weren't even belaboring that. They weren't even fighting that, weren't they?
Let me explain a little closer. He didn't mention you by name at all. He dismissed your retaliation claims on jurisdictional grounds, saying this court doesn't have jurisdiction to decide which is up on appeal right now, right?
Okay, because we had that in the very beginning, didn't we?
Yeah, that's right. The retaliation claim was filed in July or August of 2024, right? But remember, we didn't have a retaliation against the DOJ yet because you hadn't.
I hadn't started yet, yeah.
So anyway, I didn't add the retaliation claim in this instance because the retaliation issue is in front of the Court of Appeals. So in this instance, I just added your wage theft claims to the Court of Appeals or to the new complaint, and understand that your injury claims are already in front of the agency on the FTCA action, which went to the agency. I've been calling it the last day of May, first day of June. I have a FedEx receipt, so don't worry like that if I don't know or not. Like I have the FedEx receipt when it was received.
Gotcha.
Yeah. So again, for those of you maybe who don't remember, who haven't been in this, there's two, there are now 3 different tracks that this case is going. For a subset of folks who are like almost purely 1099 with their government agencies, and that includes some Social Security folks and some VOA folks, and some USPS people and so forth. We have a Form 95 or a Federal Tort Claims Act, which has to go through the administrative process. So those have all but like I think 5 or 10 of new folks that have added themselves to the case recently. Those have all been filed with the agency. Now, for me to have filed on that case, I had to be able to argue that you were wrong. You were illegally classified as an independent contractor. That was the tort that we brought in those instances. And so those were all submitted, like I said, the last week of May, first few days of June. That's when the 6-month clock started. And that is really, so remember, at the state level, for those of you who haven't been tracking, all of the states that I verified for each one of you, I pulled state law into each one of you that submitted a document. All of the states in the union, except like 1 or 2, like Mississippi doesn't have a specific statute that says it's illegal to misclassify. So in Mississippi, I have to rely on case law that says that it's fraud to classify someone as a 1099 when there actually should be a W-2. So I found a way to shoehorn in each of the state laws. These are not federal law cases, but they're state law cases against the federal government. And the way you bring those cases is under a statute called the Federal Tort Claims Act. So those have all submitted to the government in, like I said, the last week of May, except for a few stragglers, last week of May, early June. Then we have the Lambro case, which is Jason by himself which was the original filing in January of 21. Then we have, the Jordan Justice case, called the Jordan Justice case, which is parallel to the Lambro case. Jason's in the second case also, but under a different setup. And that's the one that's up on appeal right now. It's still very much alive as it relates to the justices and as it relates to all the opt-ins. I've amended that complaint, again, for the purpose of moving discovery, because because the government is just sandbagging in this case. Then we have the Court of Appeals case in which I'm arguing equitable tolling, equitable estoppel. I'm arguing retaliation. There's about four or five different issues in front of and accrual suspension. Those are the 4 issues that I'm arguing at the Court of Appeals. That's fully briefed. They have the paper copies of the brief, and now we're just waiting for them to schedule an oral argument. Normally, in my experience, I've done I think I counted about 20 cases I've argued in front of that court over the years. Historically, I get a written decision from that court within about 30 days of the oral argument. So other courts vary a little bit from 30 to 60, 90, but in this court, it's been historically pretty consistent at about 30 days. Now, as it's my habit, we're 15 minutes into this. Again, we don't have a lot of folks. This was just an update. For those of you who weren't on the last call, I have since the 23rd of July, I've significantly downsized my firm. It's one of counsel and me, paralegal. I'm operating out of my house. Virtually all of my attention is on this case alone. I have also I've initiated some conversations with the Gilbert Law Firm, because they have like 65 attorneys working at that firm. I've talked to a fellow named Kevin Owens over there, who is probably, like, the folks over at Forrester Haney, like, they knew a lot about employment law, but nothing about suing the government. The folks over at Gilbert I would suggest that they're probably my peer when it comes to suing the federal government, but they don't have the depth of experience on government contracting. So one of the guys, Kevin Owen, one of the partners over there, has done a lot of FLSA actions against the federal government, but those were as it related to W-2s within the federal government. He's done MSPB work, Merit System Protection Board work, and all that stuff. And he is the one that law firm is the one that's representing the PSCs for the illegal termination in May of 2025. Now, what Kevin and I and Ryan have discussed is that my retaliation claim, if I succeed on appeal on the retaliation claim, my claim could subsume their illegal firing case, because their illegal firing case is a breach of contract claim. And what that would mean is that they could only basically go as far as the government, they have to basically argue that the termination for convenience was illegal. And that's, not a tougher hill to climb, but it requires administrative exhaustion, like the FTCA claim, which is why they've done I think they've done like 60 CDA claims so far, which stands for Contract Dispute Act claims. And so we're going to be running in parallel. They're also going to be in the Court of Federal Claims, just under a different theory of damages. I told them I had this theory of damages all the way back when Jason and I first met in like 2020. The difficulty was, I felt like having, what could be hundreds of CDA claims going at the same time was not as efficient as bringing the FLSA claims that we have now. But I've kind of done a similar thing with the Federal Tort Claims Act. So we've got everybody covered in a bunch of different ways. And apparently they have around the same number, about 300 folks that were PSCs that in their way of thinking was illegally terminated. And what's great about that is that for some of the folks that we've learned, like since we started this, they didn't really have any unpaid overtime, things like this. This gives them a way to recover under a different theory that isn't connected to overtime or minimum wage. It's basically for firing them when the argument was that the interim director that made the move to terminate everyone, she was an illegal appointee, and the court ruled that everything she did was void, which includes terminating those contracts. I know that's going to probably raise more questions than an answer, but yep. So the question we got is: so we went in the Court of Appeals in 24 that said that Jason was misclassified. Yes, so that is a true statement. There's a separate legal issue about retaliation, and as it relates to the fraudulent concealment piece, right? So the government is arguing that where the court has ruled that this is going to make you guys glass over again, but there's a clause in the statute that gave birth to the Court of Federal Claims that says that this court is not allowed to hear any claims that are born in tort. That is not an easily understandable thing, but what it basically means, when I'm explaining, is that you can't bring like an intentional infliction of emotional distress in the Court of Federal Claims. It's claims born in contract or a violation of a money mandating statute. And my argument is the Fair Labor Standards Act and all of the Fair Labor Standards Act, including 2H, which is where you're not allowed to retaliate, is a money mandating statute. It clearly states that in the event that you can't fire anybody, and if you do, you owe them past wages and forward wages and all that business. So I've sued the government, and I think that's why I'm very confident the Court of Appeals is going to come back our way, because it's a clear interpretation of the statute. And if they don't, we'll have a fast track to the Supreme Court, because this is a court of unique jurisdiction, and meaning there's no split. It's something the Supreme Court would theoretically be interested in resolving. So anyway, that's the answer to that question. Who else has got questions today? You guys know the exercises. Raise your hand and I'll answer whatever, your emoji hand, and I'll answer whatever questions you guys have going. And if not, if you guys don't have a bunch of questions today, it's fine. I will tell you that I should be able to get back on the bi-weekly rhythm now that I'm completely moved. Hey, Russell Green, what's your question?
Yeah, Joe, real quick. So you mentioned earlier about the Jordan case appeal, yep. And I think that's one of the ones that I was on.
That's right. You're listed by name on that appeal.
Awesome. So if you can recap, how long ago did you mention? I heard you mention that something about that appeals process. Because basically, could you go over that again? Sure. The appeals process for that case.
Yep, 100%. So basically, Judge Summers ruled. Let's go back and do the timeline a little bit. So the Jason Lambro case, the original case that was filed in January 21, the Judge Summers dismissed that case with prejudice, and let's call it November of 22. I think it was November of 22, right? So sometime I have to go back and look at the timeline, somewhere between September and November 22. The literal next day, I filed an appeal. Then it went through the Court of Appeals, and the Court of Appeals actually remanded the case, actually decided in our favor in January of 2024. Then the government has a right to seek a review by, so for the guys who are getting so much of a legal education, you guys are going to be ready to take the LSATs when this is done. So the government, any appellant in any federal court of appeals, when you do an appeal, you go in front of a panel of 3 judges, and those 3 judges issue a decision, and that decision is either published or unpublished. And if it's published, it creates new law. In other words, this is the law of the court. This is what you can rely on. Our court, our 3-judge panel, issued a published decision stating that it was possible for it to misclassify its employees, and sent it back to the trial court to determine whether or not, in this instance, Jason was misclassified, and whether or not he would do overtime and minimum wage, unpaid minimum wage. The government had an option to file a motion for a hearing en banc, a motion for a hearing en banc, again, for things that you guys are getting part of your legal education, asked all the judges in that court, like 16 judges, to review the decision and decide whether or not, that to sort of get a unanimous or a split decision, whatever it is, a majority decision by the judges in that court that the panel got it right. That if it's Jason versus me in this case, let's say it's me versus anybody else other than the government, that the appellants usually have 15 days. When the government is a party, they get 45 days. And what the government did in this instance is it waited till the end of the 45 days, and it asked for and it got an extension of time. And it did that 2 times. So in January, the Court of Appeals remanded, January 24. It didn't finally make it back to Summers because the government finally decided to not ask for the motion for a hearing. It went all the way up to the Solicitor General, and they decided to not go for the motion for hearing. Then it went, so finally in June 13, 2024, it went back to the trial court. I immediately, I think on the 18th of June, turned around and filed an amended complaint. Russell, you were on that amended complaint. So was Mr. Jordan, so was Ms. Burt. All of the folks that are currently in the second case were named in the amended complaint that went in front of Summers on the Jason Lambro case. He basically never allowed us to amend that complaint. He allowed the government instead to file another motion to dismiss, which was, in my mind, facially illegal, and drag things out. So I went and filed a new complaint, and I filed that complaint, I think, in July of 2024. It was either July or August 24. Again, I don't have the timeline in front of me, but it was one of those 2 days. In that case, Russell, you were also named. So was Mr. Jordan. So was the justices. There were 8, and Miss and Marie. All of those people were named on that case. The government eventually, the government eventually moved to dismiss those claims, your claims, on a number of different grounds. One was yours and Mr. Jordan. They said it was statute of limitations problem because, and the reason they said that was because you were no longer 1099s as of 2021 was their position. Everybody was moved. Their position was everybody was moved to W-2s as of the fall of 2020. I don't think that was true, and I argued that it didn't matter because once people were moved to W-2, the overtime violations didn't stop, right? So all that to say, what we ended up with, the court ruled against us in December, and I'm getting to the answer to your question. In December of 25, the court finally ruled that that your case and all except the justices were dismissed on various different grounds. Jason's claim for retaliation was dismissed on jurisdictional grounds. Burke's case was dismissed on jurisdictional grounds because of he had another case going. Basically, they called it issue preclusion, which was, all of it in my mind was completely goofy and wrong. So I filed the appeal on that case in like January of 26. And now here we are. What happens when an appeal is filed is you have to file an opening brief, which I did, on time. Then the government files a response brief, and then I file a reply brief, which has all been done. And then we file paper copies, and that happened last week. And so the next step is they'll schedule oral arguments. And then I'll fly to DC and I'll be in that same courthouse, which is right there on like M Street, I think, right, Jason, right next to Joe's. It's right down the street from the Joe's Blue Water crab place, and across the street from the Sofitel. So I'll fly in, I'll do oral argument, which I didn't, the story I didn't get to finish telling is I get to fly 8 hours round trip for essentially 30 minutes of oral argument. The court typically allows 15 minutes per side. I've never actually been limited to 15 minutes because the cases that I typically bring are pretty convoluted, like this one. And the court ends up peppering me with questions and so sometimes I'm standing there for an hour. But in either case, I'll do the oral argument, I'll fly home, and then we'll wait for the decision, for the remand, or for whatever, for the decision to come down. If the court does what I think it should, what I think it's going to do, it'll remand back to the trial court, and then with instructions that says that the court, at a minimum, the court needs to do more fact finding on an individual basis to find out whether or not equitable, because the court ruled as a matter of law that equitable tolling couldn't apply to any of the litigants, which is sort of silly since there are like 300 litigants with language barriers and all the rest. And then the second piece is the accrual suspension rule will suggest that because my strongest argument is an argument called equitable estoppel, which is basically the argument that the government can't simultaneously take the position that the VOA 1099s and employees didn't have any rights while simultaneously arguing that they should have known about the rights and brought their claim earlier. So that's where the equitable estoppel comes in. So if the court agrees with me, and on top of the fact that we were on appeal for a better part of a year and a half, the court agrees with me on that, then everybody that was, pushed out will be brought back in. The timeline will be reset, and the damages picture will change significantly. Basically, the meaning we'll be able to reach back significantly in time as it relates to damages. And that is what I'm hoping. I have no way of proving this, but that is what I'm hoping the government will step up with a meaningful number as it relates to all of the litigants, and we can start having settlement discussions. But one thing I believe the government is counting on is Judge Summers' sort of history of carte blanche ruling in the government's favor on everything. That's what I think the government is relying on. Jason, what do you have to say about that? Jason, before I turn to you, let me make sure, Russell, did I answer the question you asked in a way that makes sense?
Yes, and I was going to follow up with, I was under the impression that the statute of limitations would go from the time of filing 3 years prior to that. So basically, it was 2021, and it should have been, in that case, 2018, and then extend from there.
That's right.
But you clarified that. So,
but Russell, you should know that that's what I argued. And that's why I tried to amend the Jason complaint in June of 21 or June of 24. That has been my argument all along. Judge Summers went to the trouble of ruling that Jason was not allowed to be a part of a collective action because he didn't sign a form at the filing in January of 21, even though the complaint has pled since the beginning that it would be Jason and those similarly situated. It was pled as a class action from the beginning, or a collective and a class from the get-go. And the court, that issue is also in front of the Court of Appeals because Judge Summers made it an issue in his December 25 ruling by accusing me of engaging in some sort of gamemanship. But he ignored the fact that he actually ordered me, like he did on the second case. What Jason, you said earlier, I want to bring a point of clarification. You said that he dismissed your claim. He didn't actually dismiss your wage and hour claim in writing, or I'd have a problem on appeal. He just ordered me to file an amended complaint with only the justices as named plaintiffs. He ordered me to do that, which by extension,
that feels illegal too.
Yeah, which by extension removed you from the filing.
So we go to the Court of Appeals. They look over our Judge Summers rulings. Do any of them like raise an eyebrow and say this isn't the way it's supposed to be done? You can't do this. This is illegal, and then call them out on this bullshit?
I've seen it happen. It's rare. I've seen it happen. I saw it happen in the Fifth Circuit in December of 23, where they basically called the judge out, and said it was basically, the court rulings on bias is that judges are supposed to avoid the appearance of bias. This is more than the appearance of bias.
This seems very biased in everything that he does.
Right, exactly. So my hope is that the Court of Appeals reads Judge Summers' decision, which is internally inconsistent. He says, for example, that the litigants, you guys had, he says, one, this court has no retaliation jurisdiction, and then says separately in the same decision that if the government had gone to the trouble of firing you guys, you could have brought a retaliation claim. And my question is, where? If we bring it to the DC Circuit, that would mean your damages would be limited to $10,000. So the only court we could have brought it in.
That's what he wanted.
Right. And the only thing we could do is bring it to the Court of Federal Claims, which is where the statute, actually makes sense, because there's not supposed to be a limit on the damages that federal employees should.
We motioned to get rid of Summers after all these things have sort of happened with him. With the Court of Appeals.
There's a saying, Jason, if you shoot at the king, you better kill the king. And there's the worry that I have is that I've already, he's already threatened me with contempt. He's going
to do that no matter what. He's going to just try and run you down and us down. He doesn't want this to go anywhere.
That much is clear. I'm hoping that the Court of Appeals has the authority sua sponte to just say this is removed. So the ideal ruling that we would get from the Court of Appeals is a remand, reversal, and removal. A removal would be where he would remove it to. They would order the chief judge at the Court of Federal Claims to assign the case to another judge.
I'm gonna keep my fingers crossed for that.
Yeah, that would be the best outcome. So, and if they ask me, and when I go to oral argument, why haven't you moved to have him removed? Why haven't you moved him to recuse himself? Because I'm like, in the thousands of cases that I've ever read, where I've maybe seen, one or two where the judge voluntarily recused himself, or an appellate court ordered him to.
Sidebar question. How far back, if we make it through to the Court of Appeals and everything goes well, how far back can we look at damages and have people sign on? 2013, 2000? How far back?
So I'm afraid. So listen, the Hail Mary pass, right? The Aaron Rodgers with his heels on the goal line throwing a Hail Mary pass, which happened I think once last year. That looks like going back in perpetuity, no limit. That's what that looks like. Now, there's another 6-year statute of limitations under a case called John R. Sands that the government stupidly raised in this case, and I attacked John R. Sands. And again, this is another law school class, but John R. Sands is a case that stands entirely on stare decisis. And the Supreme Court in Dodd ruled that if a ruling stands only on stare decisis, and no other reason, then it's not good law. And so it's been repealed. John R. Sands is in my view of the world, been repealed by another Supreme Court order in Dodd, which came down. Dodd was the case that reversed Roe v. Wade. So in that order, it said if the only reason a Supreme Court decision stands is on stare decisis, then it's not good law. So I've attacked John R. Sands in our briefing, saying it stands only on stare decisis, which means it's not good law, which means it's reversed by it's a very, again, it's convoluted argument. But if I get a good panel, they'll understand it. If I get a good smart panel, they'll understand it, and we will be off to the races.
Understood.
You, Jason, might be the only vulnerable subject because you brought the case in, but in that universe, we go back 6 years from 21 when you filed, that still takes you back to 2015. And now we're, 11 years back. But I still think, you remember when you brought the case to me, you didn't bring it to me as an FLSA action. You brought it to me as a prevailing wage action, which had already been tried in the Lee case in 2015. And that was the Court of Appeals for Federal Circuit ruled that the Service Contract Act and Davis-Bacon Act did not apply to the federal government.
I do remember. Day one, all the way through.
All right, guys. I'm not trying to. It's kind of a light lift today on the update, but I want to. Oh, look, I got some Q&A here. Let me see what the Q&A have to say. Jason, Nina. Okay, maybe you already mentioned this, but how does the fact that some VOA have been called back to work affect our case? Well, that meaning all that would do is what's called mitigate your damages, right? So that what they would do is they would look at the total damages pool. Let's say if you hadn't been rehired, you would have been offered, you would have been due $100,000, and you made $60,000. The math becomes easy there. You're still due the $40,000. So that the government would still have an obligation, or I would still argue for a complete, to make you whole, as if they hadn't done anything illegal in the first place. And as far as, again, that's everyone has a duty to mitigate their damages anyway, which means you have a duty to go out and try to get the best job you can get, try to make as much money as you can make. You're not allowed to sit around on your hands and say, well, the government fired me, too bad, I'll just sit here and accumulate damages. You have to, but I always tell when I talk to clients who are like in employment law status, if you're making $100,000 a year and you go get a job making 80 grand a year, then your damages are that $20,000 going forward for your life expectancy. So that's not nothing, right? So, I mean, for most of the people on this call, that life expectancy number is a pretty big number. So, and look, we will, when we get to that stage, we're going to hire experts, economics experts, to do all the math. And we'll have a beautifully bow tie, gift wrapped opinion that we put in front of the Court of Appeals, or not, sorry, in front of the trial court to rule on damages. And if Summers is still the judge, the odds are good we'll still have to appeal it again. So we'll see. I think I got to know all the Q&A. Who else got a question for me? Come on, it's your hour. All right, going once, going twice. Guys, I'll give you the other 20 minutes of your Sunday back. Thank you for joining me. Look for another email. I'll do as I have been doing and put this, send this around with a username and password for everyone to kind of catch up on what's happening, those who weren't able to make it. And then we'll see you guys in a couple of weeks. And again, if there's any other big updates in the interim, I will 100% send you guys an email to catch you up.
Thanks, Joe. Appreciate it.
Awesome.
Hi, Joe.
Thank you, Joe.
Thanks.
Thanks.
Take care now.
Have a good
Bye-bye.
day.
So much, Joe.